Today we have with us for the third episode of Conversations with ICC Australia, Ben Juratowitch, KC from Essex Court Chambers, and Callista Harris from 7 Wentworth Selborne Chambers, addressing the topic, can arbitrations be efficient, diverse, and credible all at once? Or in other words, can it be everything, everywhere, all at once? So our two Oscar nominees, Ben and Callista, I'll hand over to you and allow you to have a conversation for the next 20 minutes or so. And I should say that those observing today's episode will have an opportunity to ask questions during your conversation by posting them to this platform and raising your hand perhaps at the end as well. Thank you.
Hi, Ben. Good to see you. I've seen that in the past couple of weeks, you've been in hearings for some public international law cases in the ICJ and elsewhere. I was wondering, what's the mix of cases that you're working on at the moment between investment cases and pure public international law cases and commercial cases?
Well, good to see you too, Callista. Thank you, Mark, for the introduction. And I see from some of the names that have joined us that we have a small but very high quality group of participants. So I'm slightly frightened of the questions that might be coming. But on your question, Callista, if we can start with that, I suppose I'm doing 4 things. One are the interstate cases you just talked about, and climate change and the interventions in the case brought by Ukraine against Russia against the ICJ are the big ones in terms of hearings right at the moment. I'm also doing purely commercial arbitrations, particularly in the energy sector, and at the moment with a heavy emphasis on African disputes. Also court work related to those, especially anti-suit injunctions. And then lastly, investor-state dispute cases, so both for and against states, both ICSID and UNCITRAL. So that's the spread of what I'm doing. I'm keen to know from you, though, conscious that at least up till now you've had a similar spread, and conscious that you've started pupillage just this week in Sydney. First of all, congratulations. I was very happy to hear it and to see it. Can you let us know how it's been going and how you think you're going to tackle having an international practice at the Sydney Bar?
Thanks, Ben. Well, I'm only 3 days in, but it's going fantastically so far, and hopefully it keeps going going in that same direction. I've brought with me a couple of interstate cases and investment cases, so hopefully that I'm going to keep working in that space from Australia. I've been working part-time until recently, focusing on investment work and pure public international law work. And now that I'm working in Australia, I'm expecting the commercial work to pick up substantially in terms of a percentage of what I do. But I think one of the key ways that I intend to keep working in this space from Australia is by working on cases with people that I've previously worked on who are all around the world. So I think that's one good way to keep a high amount of arbitration work, even though I'm working from Australia.
One thing that people might say to you is, look, you can't be a specialist in everything. You've just got to pick your track. Are you being a commercial litigator or commercial arbitrator, or are you doing investment work, or are you doing interstate work? Because you can't do all of those things at the same time and be good and credible in them. I just wonder what your views are on that.
Well, I would strongly disagree with that, and I suspect you would as well. I think, including, especially when you're more junior, it's important to keep a mix of the types of work that you're working on, because you don't really know which direction your career is going to head in the future. But more importantly, I think that there are real advantages in working in all of those areas, and that things you pick up in one area can really help you in a different area of arbitration or international dispute settlement work. I think you would agree with that as well, wouldn't you?
Well, people say that all the time, but is it really true? I mean, what specifically?
Well, I think thinking about some cases we've worked on together, I think that in particular, it's good to have a strong, pure public international law practice or a really good understanding of public international law principles when you are working in investment arbitration. I think in the investment arbitration space, being a relatively young area of law compared to other areas of law, there's a lot of room for creative arguments, and often you can make those creative arguments by drawing on general public international law principles. So that's the main way I find working in one area helps in the other area. I don't know if you think the same thing about working in commercial arbitration as well.
I mean, for me, I think it's more skills-based than content-based, and maybe a little bit more about my own interest, in the sense that I find the pace of commercial cases and the cross-examination in commercial cases extremely interesting. And I find appearing before the London Commercial Court and sharp commercial arbitral tribunals a pretty exhilarating experience in terms of the quality of interchange between bench and bar. I really enjoy it. And the further one goes away from that, through investor state cases all the way through to interstate cases, the less fast-paced and the less interesting the process is, the less cross-examination, the less interchange between bench and bar. So for me, while I agree that there are different aspects of the different types of work that contribute to the others, I agree with what you said. In my own particular case, it's as much about having a broad practice to keep skills sharp across different areas. I know Mark asked us, he didn't say this in his introduction, but he did ask us to talk about these kinds of points before we got onto the topic, but maybe we should do that and perhaps start on efficiency and diversity. Do you want to start on that?
Yeah, that sounds good to me. So I mentioned that we have worked together before, and I was thinking back recently to the first cases we worked on together, which is about 10 years ago now, and they were 4 parallel arbitrations, 2 commercial, 2 investment arbitrations. And in those arbitrations, each of which had 3 arbitrators, all of the arbitrators, all 12 of them, were men. And I was reflecting on this and thinking that I suspect and I hope that the same thing wouldn't happen today if you're appointing 12 arbitrators. And I was wondering, do you agree with that? And do you think we're getting towards where we want to be in terms of diversity?
I agree it would be very surprising in 2023 as opposed to 2013 to have 4 3-person panels, all of which only had middle-aged to elderly white men on them, all from developed countries. And I'm glad that's in our rearview mirror. In terms of how much progress we're making, the easy answer is definitely not enough. The harder answer is where we are along the curve. I suppose we've all seen the statistics from different arbitral institutions. I think what I've noticed the most from my own practice is that no matter how much individual counsel might be focused on trying to make sure there are diverse tribunals, if it's a big ticket case and there's a client with particular pressures on them in their own organisation, they're very cautious and conservative about not wanting to take risk. And I think that leads people responsible for the ultimate decision as to which arbitrators to appoint to sometimes make quite conservative decisions to appoint people with a long track record that they will feel comfortable with. And that in turn often leads to middle-aged to elderly white men from developed countries. And I think that is changing, partly because council are getting more aggressive on saying, actually, a lot of those people are too busy and in any event, not objectively speaking, the right person for this case. And there are a string of other people that you should be considering from a more diverse group more diverse range of backgrounds, that will be as good or better than some of these other people that you might, in the abstract, feel more comfortable with, because they're newer, or they have more time, or actually they're just better with better experience, even if you haven't heard of them or they haven't been around for as long. I also think that a number of parties to arbitrations, particularly the repeat users, the big multinational companies, through their own diversity policies now realise that diversity and quality is not a dichotomy, that actually diversity works in the service of quality. And so for some clients now, whether commercial organisations or governments, we're now preaching to the converted, but there's still, I find, some degree of leap of faith involved on the client side in appointing or putting in a positive vote for a chair if you're not unilaterally in control of appointing candidates from diverse backgrounds. But it may be that I'm out of date on that. Maybe things are better than I think they are, or maybe they're worse than I think they are. So I'd be keen to know what you think, and if any of what I said you think is wrong, or if you have different views on any of that.
No, I agree with everything you said. I think that a key problem is helping clients feel more comfortable appointing arbitrators who aren't, you know, the standard choices, the usual faces. I think my experience has been the same as yours, and to double check it's not anomalous, I did have a look at some statistics, and it looks that for for institution appointees, the percentage of women has jumped up. It's way up. But if you're looking at party appointed arbitrators who are women, the percentage is still very low. It's improved a bit, but it is still very low. So I think that is the key area where we need to focus our attention. But I was also wondering that, and I think you said this, that the clients are looking for arbitrators with a long or an established track record. And I wonder if part of the solution is that we just need some more time as more female arbitrators are coming through the ranks and we'll have more established records, that it will just naturally happen that clients will be more comfortable picking not just female arbitrators, but more diverse arbitrators in general. Would you agree with that?
Yes, but in a qualified way, because if you just let time pass with the status quo as it is, then the problem won't solve itself. In fact, it'll compound because there'll be other people who are not diverse getting even more experience in the same period of time. So you've got to make an active effort to change where we are now to then allow that change to compound over time. I'm glad you mentioned diversity more generally than gender. Gender is obviously crucial, but actually now in terms of some of the people who are getting lots of appointments, I would say too many appointments in terms of their availability and how long it now takes them to render awards. Some of those are women, including because of the problem that, since we all know that diversity is an issue, a lot of people focus on, okay, well, we need to have women candidates. And actually, there's quite a small number of female candidates with a long track record. And so that actually can concentrate appointments on quite a small number of people. So I think the reference to diversity generally is important, not just with respect to where people come from geographically or ethnicity or other kinds of diversity, but also in terms of where people are in their careers as an arbitrator. My own experience is that there are lots of people who don't have as long a track record as I think you were referring to, who are actually extremely good, extremely diligent, and do have influence on tribunals with people who have been around for longer. And so I think appointing younger people is also really important. I can say that openly because I don't accept arbitral appointments, so it's got nothing to do with me. But I do think that appointing younger people to arbitral tribunals is a really important part of generating more diversity over time.
I completely agree with you. And I think in addition to having, diversity as a good goal in and of itself, I think just having a larger pool of arbitrators, it has lots of benefits, including in relation to efficiency, which was one of the other things that I wanted to talk to you about. So I think one issue that I have in relation to the efficiency of tribunals is that when you're appointing arbitrators who have very heavy caseloads, often you're getting timelines for the arbitration that are incredibly long, with hearings a couple of years at least away, because the people who are being appointed as arbitrator just don't have availability in the coming years. But either on that point or more generally, how do you think we're going in terms of improving the efficiency of arbitration?
Terribly. I mean, I think we're basically, for lots of arbitrations, and in particular the big ones, stuck with a sort of standard procedure that gets rolled out now, which is not obviously, and I would flip around the other way and say obviously not, the right procedure for every arbitration. The difficulty is that there are so many counsel now, particularly more senior counsel, who are often calling the shots on these points, and arbitrators who have just grown up with it, and that's what they know. They know what a procedural order number one looks like. They know roughly how long a procedural schedule is. Problem is that, as everyone knows, no two cases are the same, and actually some cases turn on some quite small points, and you see cases that rumble on for 3.5 years and end up getting decided on a pretty short point, which someone should have taken as a preliminary point 1 month into the arbitration, and the whole thing would have been over in 3. So I do think that it's incumbent, especially on counsel, to be identifying what the case is likely to turn on and trying to tailor a procedure according to what the case needs, rather than fitting every case into a standard procedure. I think the responsibility on arbitrators is a bit harder for them to discharge because they obviously know less about the case. But that comes back to your point about availability. Once they're appointed, why should they know less about the case? Shouldn't they be reading then? Shouldn't they be getting on top of the file and working out how things are likely to shake out and what needs to be decided when and what the best procedure is? So my own view is that some more aggressive case management by arbitrators would be a very, very healthy development, both in the big commercial arbitrations and in investor state cases, because too many are just being allowed to drag on for too long based on what seems like is just the standard form. But maybe you think I'm off the mark on that. So if you do, I'm keen to know your experience, and in particular, how realistic that is. How realistic is it to be trying to get arbitrators to engage earlier, particularly given how busy the good ones are?
I do agree with you. I don't think you're being overly pessimistic. I think you're being quite realistic. I think that you're right that once arbitrators are appointed, they, should be in the same position as the parties in terms of reading the material and being across what the dispute is. But I think part of the problem is that such detailed procedural calendars, timetables, are being set down at such an early stage before any pleadings have gone in, other than a notice of arbitration, etc. And that at that time, the arbitrators aren't really in a good position to know the size of the case or the key issues. So I wonder if part of the answer is that either there needs to be more flexibility in changing the procedural timetable once these kind of issues become clear, or perhaps at that first stage, only setting the initial stages of the procedural timetable and waiting to see how the proceedings develop. But then again, going back to what I was saying before, when you have very busy arbitrators and they want to lock in their hearing dates well in advance, I'm not sure if that's an attractive solution for arbitrators either. Do you agree with that?
I wonder if this is an area where actually arbitration should be learning from courts a bit, that there should be more active case management through the arbitration rather than, as you say, a procedural conference right at the beginning when the arbitrators don't know anything about the case. And then they have to read in for document production purposes to one extent or another. And then they really only get serious at the time of the hearing, as opposed to being more on top of things as things go and accepting a case management responsibility as the arbitration unfolds, including to make decisions where the parties' positions are contested, rather than just adopting a lowest common denominator of the slowest wins. So I think that's right. I also think the memorial structure where the legal argument, the factual evidence, and the expert evidence all goes in at once might make good sense in some cases, but definitely not in others. And it may be that whether you call it a pleading structure or call it something else, a system where there's a list of issues identified, the factual evidence then goes in from both sides, then the expert evidence goes in from both sides, and then there's legal argument based on those known quantities, has a lot to commend it in arbitration as well as it does in court. You hear lots of arbitration practitioners, particularly those who have been around for a long time, saying, oh, we don't want court procedure in arbitration. But I think that's a very reflexive and general approach. The question is what's most efficient for the case. And sometimes what I just described is the most efficient, and there shouldn't be a reflexive reaction against it just because it might resemble what's used in a courtroom. It's used in courtrooms for quite good reasons a lot of the time. I mean, now that you're going to be spending more time in domestic courts, I'm guessing, I don't know if you have any observations on that in terms of how people do or don't learn from each and the other process and the extent to which they should or shouldn't.
Look, I'm interested to see how my views are going to change as I start working in domestic courts. When I first moved back to Australia and heard that court pleadings were used in arbitrations, as someone who had only worked in arbitration up till that point, I thought that was ridiculous. I couldn't believe that court pleadings were used in arbitration. But even now, and I'm just at the start of coming to the bar and doing domestic litigation, I'm already starting to see that it would be a lot more efficient if some of those approaches to pleadings from domestic litigation were used in arbitration. So at the moment, I have an open mind, but I'm interested to see where I ultimately land after spending a bit more time in the domestic courts.
Yeah, could I ask you a question that's sort of in a sense goes back to diversity, but now with respect to counsel? I mean, one of the big problems for the arbitration niche of the profession, I think, is that the more junior aspects of it are so heavily laden with extremely talented women, but the more senior ranks of counsel, much less so proportionately. So I suppose the general question is, how do we solve that? But the more specific aspect arising from what you said is, would a system where the crucible of filings, where everything's done at the same time, fact, witness, and legal argument, and spreading it out in a more humane way over time, would that help keep more young women in this part of the profession for longer?
Look, I'm not sure. Filings are a difficulty for young women, but also for men with I think in particular young families. I think that's the main issue. But I don't think pleadings are the hardest part of the arbitral process if you're balancing a family life and your work life. I think hearings are the real issue, and potentially being away for 2 weeks, a couple of times a year, or multiple times, much more than that. So maybe a different pleading system would help, but I don't know if that's what would make the difference. I think Mark wants to jump in on that point, though.
I think he's going to tell us we've been going for too long and we need to hear from others, which is, I'm sure, right.
Or at least me. At this point, I haven't received any questions, but if anyone has a question, please raise it in the chat group, or just turn on your camera and you can speak. And in the meantime, let me just bring us back to the broad topic of whether arbitrations can be efficient, diverse, and credible. Can it be all those three things at once, or do you have to choose? And I'm reminded of an expression that arbitrations can be expeditious, cost-effective, and correct, but it can't be all those three things. You have to choose two of the three. Do you want it to be fast and correct, or do you want it to be expeditious, but not cost-effective and correct? So with your topic, can all three be achieved at once, or do you have to maybe prioritize those different qualities for different cases?
I think not only is there a false dichotomy, but in your example, I don't know if trichotomy is a word, but hopefully you know what I mean. I think it's a false trichotomy. I think they're mutually supportive. Some of the reasons we've been discussing, that a more diverse pool, whether of arbitrators or counsel, brings people with more availability and more skills. Efficiency means that things are getting decided on the right point in the right time frame, rather than being kicked off into the long grass and only being decided when everyone's forgotten what was actually said at the hearing, let alone remembering what was written in the first brief. So I think efficiency actually leads to better decisions, not worse ones. And as for credibility, who's measuring that? If it's clients, they definitely want it faster and better. And I don't think they accept, and for what it's worth, neither do I, that a faster, more efficient, more concise decision based on more efficient, concise submissions made by more diverse counsel and decided by a more diverse tribunal in any way decreases credibility, whether you measure that through jurisprudential quality or otherwise. On the contrary, I'm now repeating myself and against my efficiency point, but I really do honestly believe they're mutually supportive. But I have no idea what Callista's view on that is, but that's mine.
Well, maybe if I can ask Callista a different question, which has come from the chat forum, which is how important do you think having a PhD is to the practice of international arbitration generally, and in particular the practice of public international arbitration?
I think it's quite important, or at least very helpful, when you're in the public international law space to have a PhD, simply because a lot of the other people in that space have PhDs as well. But I would never suggest to someone that they should do a PhD for the sake of their career. It is a huge undertaking, so I would only recommend that someone do it if it was their passion and something they really wanted to pursue. But I think in the public international law space, it definitely does help to have a PhD. Do you agree with that, Ben?
No, I agree with this. I agree with the second part of what you said, which is no one should ever undertake a PhD for instrumental reasons. People should only do it if they've got a topic they're passionate about and want to spend the time on it. I don't agree with the first part in the sense that I think that what makes a difference in terms of people getting instructed and doing well in cases is their legal skills, most of which don't have all that much to do with writing a PhD. Writing a PhD develops some skills, but not all, and some of those skills you can develop doing other things. So I can think of examples where there are extremely successful counsel and arbitrators in all the different areas of practice that we've been talking about, with and without PhDs. So in my own view, actually, maybe it matters a little bit at the beginning in certain areas of practice for certain people, but in the scheme of things, in my view, it's not important at all. I'm glad we disagreed on something.
Well, yeah, I'm maintaining my position. I still
I
disagree.
I would not have expected it to be otherwise.
I think that it definitely doesn't make you a better lawyer in this space having a PhD, but I think it is something at least some clients notice.
And could I just perhaps make an observation in relation to Ben's earlier point about the benefit of early hearings and tailoring the procedure for the specific case that you're dealing with, which of course I think we all agree with. But one caveat that I would issue, which is whether or not that tailoring process is appropriate for all cases, in particular those that are relatively low value. The standard procedure may well work better rather than trying to be too fancy in trying to develop a bespoke procedure, which can lead to delays between counsel trying to reach agreement on exactly how that process should look like, and potentially confusion to the parties and the tribunal. It may be for standard, relatively low value, not so complex cases, that the standard procedure that's been used for quite some time is perhaps more appropriate than trying to change things too much. What do you think about that?
You want to go first, Callista?
No, I completely agree with you, Mark. I had, when we were talking about gains in efficiency, I had more in mind the monster cases that get out of control. In the situation you're talking about, I completely agree with you that it'll be most efficient to proceed in that way.
Yeah. My only point is you've got to apply your mind to the question. You have to start somewhere, and we have a default position. And once you've applied your mind to the question in any given case, the answer might be, actually, we should just do what we all know. There's no point wasting time and effort fighting about anything else. And that might, in the scheme of things, be lots of cases. My point was only, it's not right for all cases, and we should be applying our mind to that question at the beginning. I think the counsel point's important. It depends a lot on how cooperative counsel are and what sort of instructions they're getting. Because if they're getting instructions to just be a pain in the neck, or that's their natural reflex position, then it's a more complicated proposition. But that's where arbitral tribunals are important, because if they're on top of it early, then they can sort that out.
Thank you, Ben and Callista. Let me just finish with one last provocative question, which is, to what extent do we need to guard against hypocrisy when it comes to diversity? And I have in mind a case that I was involved in some years ago where our opponent was led by a woman, and she appointed a male, a middle-aged arbitrator of the type that Ben was describing earlier. We did something similar, I'm afraid to say. This was probably back in 2013, so at that end of the range that you're looking at earlier. But I remember clearly our opponent insisting that the chairperson had to be a woman, whereas they had not done that. And I've been involved in other cases where similar dynamics have played out. How do we guard against that hypocrisy, and any observations on that?
Stop yourself from getting in that position by both appointing a man in the first place?
Yes, which is what happened in those cases.
Yeah. I mean, I think you can't measure diversity as against one case. You've got to look at diversity over the breadth of what's happening in arbitrations generally. And there will be some cases where there are 3 men on a tribunal, and there might be good reasons for that for those individuals in that case. I don't think there's any point jumping up and down about a tribunal that has 3 men on it. The problem is when, for no good reason, that's the vast majority of tribunals. And I think we are moving away from, or have moved away from that. But I do think that diversity needs to be looked at systemically rather than case per case, accepting that the flip side of that is if you don't think about it in every case, then you'll have the systemic problem. So you've got to think about it in every case, but that doesn't necessarily tell you where you'll end up. I think the main thing is to acknowledge the issue in the decision-making process, get it on the table, discuss it openly, make sure no one's yielding to conscious or unconscious biases, and then make the best decisions you can, all things considered. But I don't think you can change the whole world in one case.
Callista, do you have a view on that, or our topic more generally as to whether arbitrations can be efficient, diverse, and credible? And perhaps you can give some concluding remarks, and then perhaps Ben may want some as well, and then we can wrap this up. Thank you.
Yeah, I think on that point, but more generally, and perhaps pulling out a theme of what we've been discussing today, I think the bottom line is just thinking about these issues and making the decision that is best for the particular circumstances of the case, rather than proceeding on autopilot and not turning your mind to these issues, both relating to diversity and to efficiency. And if we do that, I think we will end up with a process that is more credible and legitimate, not less so. Ben, on this last point, would you like to disagree with me again?
No, I'm definitely not going to disagree with that. I'm only conscious that we're over time, and looking at the very high quality of the people on this participant list, I think we should stop taking their time. So it was a pleasure to speak with you, Callista. Thank you, Mark, for inviting us to have this discussion. And even though I haven't spoken to you all, a great pleasure to see names of friends on the list of attendees. Thanks for making the effort to come.